Good morning. It is Saturday, January the 6th. I'm Ali Velshi. It's been 3 years since a mob attacked the United States Capitol as part of Donald Trump's desperate attempt to cling to power after losing the 2020 presidential election. That attack lasted only a few hours, but the long shadow of that violent insurrection continues to loom large over American democracy, especially now as the 2024 race heats up. But both the twice impeached, multiply indicted former president and the current duly elected president understand this. That's why January 6th is a central component of each of their presidential campaigns, albeit in vastly different ways. President Biden gave the first major speech of his re-election bid yesterday, and he used it as an opportunity to reflect on how the insurrection exposed Trump's complete disregard for America's constitutional and democratic values and emphasized that the former president remains a danger to democracy.
This is the first national election since January 6th. Insurrection placed a dagger at the throat of American democracy since that moment. We all know who Donald Trump is. The question we have to answer is, who are we? That's what's at stake. Who are we? In the year ahead, as you talk to your family and friends, cast your ballots. The power is in your hands. After all we've been through in our history, from independence to civil war to 2 world wars to a pandemic to insurrection, I refuse to believe that in 2024 we Americans will choose to walk away from what's made us the greatest nation in the history of the world.
In contrast, Donald Trump has gone to great lengths to try to rewrite the history of the insurrection. He said that January 6th was, quote, a beautiful day. He calls the people who've been charged or convicted for storming the Capitol martyrs and hostages. Trump enters the 2024 race both as the undisputed frontrunner for the Republican nomination and as a criminal defendant facing a total of 91 charges in 4 different jurisdictions, including a number of charges related to his role on January the 6th. With recent polling showing a close race between Trump and Biden, there's a very real possibility that an insurrectionist could return to the White House and use the powers of the presidency to exact retribution against his political enemies, as Trump has openly and repeatedly vowed to do. It's a predicament that has given rise to a number of constitutional questions that our justice system has never had to consider because an insurrectionist has never before run for president, nor has a former president ever been charged with a crime. Many of those questions remain unresolved, and they could fundamentally alter the dynamics of this year's elections, with the first-in-the-nation Iowa caucuses just 9 days away. That tension was on full display last night when the Supreme Court of the United States agreed to consider whether Trump is ineligible for Colorado's Republican primary ballot. Last month, Colorado State Supreme Court ruled that the former president should be barred from the ballot because of his actions leading up to and including on the day of the insurrection. The justices are scheduled to hear oral arguments in that case on February the 8th, which is lightning speed by Supreme Court standards. Trump's eligibility to run for office has been challenged in 34 states. It's produced mixed results so far. A number of lawsuits have been dismissed. Others have been pending in the court. The Supreme Court is not only going to decide if Trump may appear on Colorado's primary ballot, but it may determine his eligibility to run in the entire general election. Maine is the only other state so far to rule that Trump is constitutionally disqualified from appearing on the ballot. But due to the unprecedented nature of this entire situation, officials in both Colorado and Maine are operating with great restraint and have put their decisions on hold to allow higher courts to weigh in on the matter. In her decision, Maine's top election official, Secretary of State Shenna Bellows, concluded that, quote, Mr. Trump was aware of the likelihood for violence and at least initially supported its use, given he both encouraged it with incendiary rhetoric and took no timely action to stop it. The weight of the evidence makes clear that Mr. Trump was aware of the tinder laid by his multi-month effort to delegitimize a Democratic election and then chose to light a match. Maine's Secretary of State Shenna Bellows joins me now. Secretary Bellows, thank you for being with us this morning. We appreciate your time.
Good morning, Allie. Thank you for having me.
I want to begin with your decision, the quote that I just read about the conclusion you drew that Donald Trump engaged in insurrection. It's not dissimilar to what the Colorado Supreme Court, in a very lengthy decision, underscored. They looked at all the ways you can interpret rebellion and insurrection and determined that Donald Trump had engaged in one. You held a hearing before coming to the decision that you made. I want to just understand for our viewers the process you used to come to the decision to remove Donald Trump from the ballot, at least, if the Supreme Court supports that decision.
Thank you so much. And it's important to understand the process because in this country, what makes us great is we follow the rule of law. And in Maine, because of course, under Article 1 of the Constitution delegates to the states the authority to administer the elections. In Maine, once the Secretary of State qualifies a candidate for the ballot, any registered Maine voter may, within a week, file a challenge to the qualifications of the candidate. And that is predicated on a Maine law that requires and delegates the authority to the Secretary to ensure that every candidate seeking access to the primary ballot meets the qualifications of the office they seek. Once registered Maine voters file a challenge, and in this case, there were 5 voters who did so, I am required under the law to hold an administrative hearing within 5 days, and then within a week of the hearing proceedings to issue a decision. And that initiates the process whereby then any of the parties, the challenger or the candidate, can appeal to Superior Court, and then the Maine Supreme Court, and then the U.S. Supreme Court. And just one more thing, in that hearing, both parties are entitled, and in fact were, to be represented by counsel. So they had attorneys, they can present evidence, witnesses, engage in cross-examination and legal argument. So that's our process here in Maine.
Tell me, one of the things that NBC talked to you about in the past, after this discussion about the Section 3 of the 14th Amendment started to float, was all of you secretaries of state who run elections across the country were conscious of the fact that any decision you take will be challenged in other courts, in your state Supreme Courts and the Supreme Court of the United States. How did that influence your decision making, understanding that this was not a routine decision for you? This is possibly one of the most consequential decisions you and other secretaries of state will ever make in the history of this country.
This is the process. This is the rule of law under the oath that I swore to uphold the Constitution. And so on the last page of my decision, I voluntarily suspended the effect of my decision pending appeal to the Superior Court, and indeed welcome this U.S. Supreme Court engaging, because our job as election officials isn't to make the laws. Our job is to follow the law, no matter where the law takes us, and to do as the courts direct. And so that is what we will do under the law and the Constitution, which is the only consideration we can have.
Wait, and I noticed that you said this a few times, so that's where you have decided you're going to be, what you're going to be driven by. There are differing opinions in the United States. Even in your own state, it's elicited mixed reactions, even among the Democratic representatives. Congressman Jared Golden said, quote, "I voted to impeach Donald Trump for his role in the January 6th insurrection. I do not believe he should be reelected as president of the United States. However, we are a nation of laws. Therefore, until he is actually found guilty of the crime of insurrection, he should be allowed on the ballot." Now, Congressman Chellie Pingree, also of Maine, said, quote, "The text of the 14th Amendment is clear. No person who engaged in an insurrection against the government can ever again serve in elected office. Our Constitution is the very bedrock of America, and our laws, and it appears Trump's actions, are prohibited by the Constitution." The crux of the debate, I guess I want to ask you about, is 2 parts. One is, do you think that Donald Trump has sufficiently been, that it's been litigated that he was involved in an insurrection? And number 2, do you believe that this is ultimately a political decision or a legal decision?
My decision is a legal decision under the Constitution that I swore to uphold. And I think that's really important. And, you know, in my decision, it's 34 pages. People can read it on the Secretary of State's website. I make it very clear that the decision would have been clearer should there have been a conviction or a guilty or not guilty verdict in a criminal court of law. But that's not what Section 3 of the 14th Amendment says. It says engage in an insurrection. And the events of January 6th were tragic, unprecedented. They were an attack, not only in the Capitol, but also on members of Congress, on the former vice president, and resulted in 7 deaths. But it was also an attack on the peaceful transfer of power and on the rule of law. And the weight of the evidence demonstrated that Mr. Trump, these events happened at the behest of the outgoing president and with the knowledge and support of the outgoing president. And the U.S. Constitution does not tolerate an assault on the peaceful transfer of power. And furthermore, my job as Secretary of State in Maine, as delegated to me by the Maine legislature, is to ensure all of the qualifications. So I cannot place an 18-year-old on the ballot or a non-citizen running for president on the ballot or someone who's violated the 22nd Amendment. I couldn't place Barack Obama or George W. Bush on the ballot. I must ensure that all candidates meet the qualifications of the ballot. And the qualifications in the Constitution are not a menu. They are the requirements under our founding document.
They're not a menu. Important note that it is a disqualification. It's not a penalty. I'm a Canadian who has become an American citizen, so you couldn't put me on the ballot. That wouldn't mean that there's anything wrong with anything I did. I don't meet the qualifications.
I cannot. With all due respect, Ali, I cannot place you on the Maine ballot.
We're neighbors. It's all good. It's all good. Shanna Bellows is the Secretary of State for Maine. Thank you for being with us this morning. We appreciate it.
Thank you so much.